Happy New Year, California real estate investors and homeowners. But how happy it is may depend on one or more of the new real estate laws and whether you understand them or not. Knowledge is power, and this video is here to give you some serious power.
Welcome to Rock Real Estate with Stu Simone, where we make real estate informative and fun. And now, here's your associate broker, real estate attorney, and mortgage loan originator, Stu Simone.
Hey everyone, welcome back to Rock Real Estate. This is Stu Simone, and I hope you had an amazing start to the new year. Today we've got some very important updates that all real estate investors and agents, brokers, and business owners need to be aware of. 12 new California and federal real estate laws for 2024. So grab a cup of coffee, hit that like button, and let's dive right into the dirty dozen most important new real estate laws. Number 1. Flipper disclosures for properties resold within 18 months, AB 968. So first, let's talk about a law that applies to real estate investors, specifically flippers, or what we call rehabbers. AB 968 introduces flipper disclosures. All sellers accepting an offer within 18 months of their purchase of the property must disclose repairs and renovations, including the contractor's name and contact information, along with permit details. Now, the good news is that this law aligns with the Seller Property Questionnaire, or the SPQ requirements, which reduces the impact on day-to-day practices, at least for licensed real estate agents. AB 968 becomes effective on July 1st, 2024, so you can be prepared for it. ADUs as condos, AB 1033. Now here is a new state law that proves beyond a doubt that California is leading the way in eliminating the detached single-family residence. AB 1033 grants local agencies the authority to allow for the separate transfer of accessory dwelling units, or ADUs. ADUs, commonly referred to as granny flats or in-law units, are independent, smaller housing units located on the same lot as the single-family home. Till now, it would have been unthinkable to consider that one of these units could have a separate owner from the main house. I mean, think about it. You can convert your garage, and let's say it's attached to the house or even underneath the second floor, and then it can be owned by somebody else. The catch? The ADU must be transferred as a condominium, following the guidelines of California condo law, namely the Davis-Sterling Common Interest Development Act and the Subdivision Map Act. Lien holders must consent with a right to demand lien payment or modification. If the property is within a homeowners association or HOA, their approval is also required. So while this law opens the door for ADUs to be separately conveyed, it's possible that practical challenges may limit widespread adoption. I mean, it's going to be interesting to see how the legal descriptions will be drawn up. I believe that surveyors may be required. Appraisers and inspectors are not capable of this, so that leaves surveyors. Or maybe a new business niche will open up just for this task. Law number 3, AB 1584. This bill, which takes effect in 2024, aims to unlock the potential of accessory dwelling units, or ADUs, by declaring unenforceable any covenants, conditions, and restrictions, or CC&Rs, that limit the construction of ADUs on single-family lots. Now, there's nothing groundbreaking in this bill, but AB 1584 does continue the trend by the state government to pass new laws that encourage the construction of ADUs and make ADUs a common sight in every California neighborhood, whether there's an HOA there or not. Number 4, small claims court limits have been increased by SB 71. So SB 71 increases small claims court limits for natural persons. The limit is now $12,500, and for non-natural persons or entities, it's $6,250. Now, this is actually significant for the residential real estate industry. Remember, the mediation and arbitration clauses in the CAR agreements carve out an exception for small claims court. This increase in limits might be a game changer for those buyers or sellers with damages in the $10,000 to $20,000 range. New law number 5, online notarization by California notaries, SB 696. Shifting gears to 696, this one's another industry game changer. Starting at the beginning of the year, online notarizations by out-of-state notaries are officially recognized, provided they comply with their jurisdiction's laws. Now, that's not such a big deal, but this part is. Pending the Secretary of State certification, or by 2030 at the latest, California notaries will be authorized to conduct online notarizations. The technology will feature robust security measures and 2 forms of identity proofing. Now that we can have our deeds recorded online in virtually all counties, This will make property purchases and sales a lot easier. Probably going to disrupt the notary business, as notary publics will no doubt have to develop online websites and delivery systems to stay busy. New law number 6. New eviction rules for California 1 to 4 unit residential rental properties, SB 567. This is a game changer in the California landlord-tenant landscape. Let's face it, the new 2024 laws just make it more obvious that California is the most tenant-friendly state in the union. This bill by Senator Maria Elena, Democrat of Los Angeles, will strengthen the requirements for forming 2 specific types of no-fault tenancy terminations that are regulated under the existing state law. Now, these are situations where 1, the owner or his family will move into the unit, and 2, the owner will substantially remodel the unit. Now, this law becomes effective on April 1st, 2024. So first off, new regulations for substantial remodel of a rental unit. Since its inception, the TPA has allowed for an owner to recover possession of a rental unit to substantially remodel it. SB 567 doesn't take away that right, but does require owners to include specific language in the termination notice regarding the work to be performed and the tenant's right to reoccupy the property if the work isn't commenced or completed. The new changes also require copies of any required permits for the work to be provided with a notice to the tenant as well. Finally, the legislation requires the notice to inform the tenant that if they are interested in reoccupying the unit following the substantial remodel, the tenant must tell the owner and provide contact information to the owner. Now, secondly, changes to owner move-in rules. SB 567 also amends the provision in the TPA that permits an owner or their family member, as defined, to move into a unit. The new law narrows the definition of who qualifies as an owner for the purposes of an owner move-in and sets new residency requirements. Owners who hold their properties as individuals with family members in family trusts, and in some cases through a partnership or LLC, can still qualify under the legislation to exercise the owner move-in option. The legislation also sets time frames for how quickly the owner or their family member must move in and how long they must reside in the unit. The intended occupant must reside in the unit for at least 12 months and must move in within 90 days after the tenant leaves. There's also stronger penalties for violation of the TPA. Starting on April 1st, 2024, an owner who improperly terminates a tenancy or raises the rent beyond the maximum amount under the TPA will now face severe consequences. Actual damages, which we'll discuss in detail in a moment. Reasonable attorney's fees and costs at the discretion of the judge. Up to 3 times actual damages for willful violations and punitive damages. And the Attorney General is authorized to seek injunctive relief. Let's talk about actual damages for wrongful termination. SB 567 gives displaced tenants the right to sue property owners for violating either of the above provisions. In addition to recovering actual damages, the wrongfully displaced tenant can recover punitive damages, treble damages, i.e. triple the actual damages, and attorney's fees and costs. On top of that, a property owner who wrongfully displaces a tenant to demo or substantially remodel the property must also offer the property back to the displaced tenant at the same rent amount and lease terms, along with reimbursement for reasonable moving expenses. The law introduces the concept of actual damages for wrongful termination or charging rent beyond the imposed limits by the TPA. SB 567 outlines that in a material violation of TPA, landlords could be liable for actual damages. Attorney's fees may be assessed at the judge's discretion, and if the violation is willful, the damage award could be tripled with an additional penalty on top. All right, throw that into your head. Now let's talk about numbers. Actual damages is a somewhat flexible concept in the law, depending on expert testimony and jury decisions. In a worst-case scenario, from the landlord's perspective, a wrongfully terminated tenant could claim the difference between actual rent and market rent multiplied by the intended length of the occupancy. So consider this example. The rent difference is $500 and the tenant planned to stay for 10 years. The damage award could potentially be a staggering 500 times 12 times 10 times 3 for willful acts, resulting in $180,000. All right, the bottom line here is crystal clear. If a landlord is contemplating raising the rent, let alone evicting a tenant, consulting with a knowledgeable eviction attorney is absolutely essential. Now, there's void termination notice under SB 567. That law introduces another powerful penalty against landlords. It states that an owner's failure to comply with any provision of this section shall render the written termination notice void. Thus, any violation of the TPA voids the termination notice, and void means that it never happened. The landlord would need to start all over again. And don't forget, when using any of the no-fault just cause grounds for removal, like the 60 90-day notice, the tenants are entitled to relocation costs equal to 1 month's rent. And many cities and counties in California require more substantial relocation costs. Hello, Los Angeles? This new law will not only affect existing landlords, but will have an impact on buyers of 1 to 4 unit residential real estate, as it will be more preferred to purchase properties with no existing tenants. Number 7. Phew, that was a long one. All right, new law number 7. Tenants with criminal records, AB 1418. This prohibits cities and counties from enacting crime-free housing programs and nuisance ordinances that require landlords to evict or refuse to rent to those with prior criminal convictions. Number 8. Accommodations for disabled tenants, AB 1620. This law allows local jurisdictions to require landlords whose units do not have elevators to allow physically disabled tenants to move into similar units on a ground floor and keep the same rent rate and lease terms. New law number 9, increased height limits for ADUs, SB 897. California's housing landscape is evolving, and accessory dwelling units, or ADUs, as you've been hearing, are increasingly important in the government's quest for more affordable housing. So SB 897 will probably significantly impact ADU construction, establishing new height limits and allowing 2-story ADUs. The updated ADU height limits require a minimum of 16 feet for all detached units, ensuring ample space. Additionally, detached ADUs can reach up to 18 feet high, ideal for space-constrained areas under specific conditions. Eligibility for 2-story ADUs depends on location, with units near public transit or existing multi-story, multifamily dwellings, allowing a height of up to 20 feet, enhancing design flexibility and space utilization. Number 10, security deposit limits. AB 12. Now let's talk about AB 12, which puts a limit on security deposits for landlords and tenants. Starting July 1st, 2024, landlords can only collect 1 month's rent as a security deposit, max, in addition to the first month's rent. And unlike current law, this also applies to furnished units. However, there is an exception for small landlords. A small landlord, defined as a natural person owning no more than 2 residential rental properties with no more than 4 units combined, can still collect 2 months' rent as a security deposit. This includes family trusts and LLCs with natural persons as members. But even for small landlords, if the tenant is a service member, the security is limited to 1 month's rent. On the plus side, landlords with existing security deposits exceeding 1 month's rent before July 1st, 2024, can continue to retain them. New law number 11, the ability to pay screening for Section 8 tenants, or SB 267. This law focuses on Section 8 tenants and those receiving government rent subsidies, aiming to shift the screening process from credit history to ability to pay. All right, here's the deal. Under SB 267, landlords are now prohibited from using a person's credit history in the application process without first offering the option for the applicant to provide alternative evidence of their reasonable ability to pay. It's a significant shift towards a more inclusive and fair screening process. So what does this alternative evidence include? Well, government benefit payments, pay records, and bank statements are just a few examples. The tenant applicant only needs to show a reasonable ability to pay their portion of the rent. Once the applicant chooses this option, number 1, the landlord is obligated to provide them with a reasonable amount of time to respond with the alternate evidence, and 2, landlord must reasonably consider this alternative evidence instead of the person's credit history when deciding to offer the rental accommodation. It's important to note that while credit history is off the table for Section 8 tenants and those with rent subsidies, landlords can still request information or documentation to verify employment, inquire about landlord references, or verify the identity of the person. And finally, the Dirty Dozen, capping off a law number 12. This is a federal law, FinCEN's beneficial ownership rule. Finally, this new federal law applies not only to real estate investors, but just about any entrepreneur and small business owner. If you own 25% or more of a limited liability company, partnership, or other small entity that owns real estate or runs a small business, and any of these is a company, or are the president, CEO, general counsel, or CEO, COO of a company, or perform a similar role, or have substantial control over any company, then listen up. This is big. If you check any of those boxes, then starting in 2024, you will need to register or be registered in a new federal database designed to identify and ferret out criminals, money launderers, and other bad actors who use companies to conceal their identities and evil deeds. That registration requirement will apply for every company for which you answered yes to any question in the previous section, and maybe more. Each registration will need to include your name, date of birth, residential street address, can't use a business address, a driver's license or other ID number, and a photograph of the document substantiating that number. This information will mostly be collected online. Any company that already exists as of January 1st, 2024 will need to register by the end of that year. Now, companies newly created this year will need to register within 30 days after creation. Special registration requirements apply to anyone who files paperwork necessary to create companies. Now, it remains to be seen whether those requirements will lead law firms to stop handling that kind of work. So there you have it, a selection of what I consider the new 2024 laws that impact real estate, the Dirty Dozen. If you found this information enlightening, please don't forget to give us a thumbs up, subscribe for more in-depth financial insights, and share your thoughts in the comments below. Stay tuned for more updates as we navigate the ever-evolving landscape of real estate finance. Remember, Rock Real Estate is all about maximizing your most important asset, your real estate. Till next time, stay informed and make your decisions based on research, so they will be wise ones.